Welcome to another edition of Dad's Divorce Live. I'm Sean Garrison, your host and editor of DadsDivorce.com. Today we are joined by Representative Lowry Snow, who is a state representative in Utah who recently sponsored some shared parenting legislation that recently went into effect. Thank you for joining us today, Lowry.
Thank you. Thank you for the invitation.
Absolutely. To start with, can you walk us through the key points of this bill and what it will hopefully accomplish?
The key points really, in my estimation, are twofold. One benefits the non-custodial parent, and the other benefit accrues directly to the children involved. Previously, we have in our state a minimum visitation schedule. In the event the parties are not able to reach an agreement with respect to visitation in cases where one party has sole custody, the court then usually applies what's known as the minimum visitation schedule that's set out in our statute. This particular bill provides an alternative parent time schedule that expands and goes beyond the minimum schedule to benefit the non-custodial parent, giving them some additional time as an alternative. The other benefit, as I mentioned, is I think the studies and the data shows that the more time we can put these children, particularly those in a divorced family, to spend greater time with each parent, it ultimately benefits the children. They do better, and I think the bill was designed with those 2 points in mind.
Absolutely. And now you mentioned that the bill allows non-custodial parents 145 days each year with their children. The former minimum was 110 days, but I understand that became kind of a de facto maximum. Can you explain, I guess, the reasons for that, how that kind of came to be?
Sure. I think when the minimum schedule was initially adopted, and the reason it actually indicates in the code that it was minimum was that the courts and I think the lawmakers anticipated that the parties would work together and on their own expand that. But the reality is, once that was adopted in the decree, the custodial parent really, in many cases, utilized that as the maximum and is just unwilling to expand visitation beyond that. As a result, you had non-custodial parents, primarily a lot of fathers out there, who were held to that strict minimum schedule, and trying to get the custodial parent to expand visitation beyond that was, in many cases, nearly impossible. And so, while it was intended to be a minimum schedule, the reality was, as it was utilized, it tended to cap the visitation, and in many cases, to many non-custodials, I don't want to say to their detriment, but to their discouragement.
Sure, and this bill also affords non-custodial parents overnights with their children on both Wednesdays and Sundays. Can you explain the significance of that and how it's potentially a benefit for both parents involved?
Sure. With respect to the weekend visits first, if you talk to, and I used to do a lot more family law that I'm currently involved with, but when you talk to the non-custodial parent and they talk about those who are deeply involved and committed to their children, the Sunday night visit or the time together leading into Sunday night was always a little bit I guess traumatic, because while they enjoyed their time together, it ended abruptly on Sunday night. The children had to be returned to the custodial home on Sunday. This extends that. Instead of the non-custodial having to end the visit on Sunday night, allows them to keep the children Sunday night and put them, deliver them to school the next day. And it just makes a much better weekend visitation. And likewise on the weeknight visitation, instead of having to have the child after school, have dinner together, and then return the child back that same evening, they're able to take their children, have them the rest of the evening, put them to bed, and deliver them to school the next day. And so it's a much more I think, suitable and a better environment for them exercising that parent time together in those situations. That's what it was designed to do.
Absolutely. And now some lawmakers have argued that adding another option could lead to increased litigation as parents return to court to modify and amend their divorce decrees. How would you respond to that concern?
Well, I think as practitioners will know, this alternative schedule is intended to be available both at the outset when the decree is final, but it potentially provides an alternative for post-decree dispositions as well. I suppose there can be some litigation that are spawned as a result when the non-custodial parent believing that they should qualify for this and having to pursue that through the courts. But I think we see a lot of cases that are settled both post-decree and at the outset. And I think one of the things that this statute or this revision will provide is an alternative for settlement. And if the custodial parent recognizes at the outset that this alternative may be a viable plan that the court would look at, I think it actually will help promote that. And then I think as most practitioners know, it's not necessarily in settling these cases in either A or B. They can also form and develop their own visitation or planned parent time together. And I think the reality is, in my view, having this on the books will actually help facilitate parties developing their own plan, customizing it to their own needs and the needs of their children.
Sure. And is there anything else you'd like to add, Lowry?
No, I don't have a great deal to add except that it's been an honor to work with those that have supported this. We've had a lot of great support from parents, from non-custodial parents. The Utah State Bar Family Law section actually were the architects of this, and this is something they've been working on for many years to see accomplished, and I think we need to give credit to them and practitioners who work with these family laws every day and try to alleviate issues and tensions between parents and children.
Absolutely. Well, thank you so much for your time today, Lowry. We really enjoyed having you here on Dad's Divorce Live.
Thanks very much, Sean, and again, thanks for the invitation.
That was Utah State Representative Lowry Snow. To read more articles regarding shared parenting and child custody, make sure to visit dadsdivorce.com. This has been Sean Garrison, and that'll do it for another edition of Dad's Divorce Live. Thank you for watching.